Can you please briefly explain the Supreme Court hearing on the Patient Protection and Affordable Care Act, starting with the parts of the ACA that are going to be argued before the Supreme Court?
Well, there's been quite a widespread challenge to the law. It's come from many states, and there's various approaches to striking down the law. But the main one is around the mandate for individuals to have insurance. And the core of the opposing idea is that the Constitution doesn't allow the government to force the purchase of a product. And the subtlety there is that it doesn't allow the government to mandate around inactivity. In other words, the absence of insurance is considered to be a non-action, and therefore the government shouldn't be able to compel an action of this type that involves a commercial purchase.
What are the arguments of the opposing sides?
Well, the argument for the bill on this narrow constitutional matter seems to revolve around the notion that the idea that this is a purchase of a product is rather a technicality. It's not really that different from requiring the purchase of automobile insurance, for example, and that there'd be many examples where the requirement to purchase a product is either implied or required by the law. So unless you're going to be willing to strike down laws that require automobile insurance, you should be willing to sustain the mandate. The opposing side's the argument I gave earlier, which is that the government shouldn't be allowed to compel individuals to purchase a product in the commercial market.
What are the possible rulings from the Supreme Court?
Well, I'm not a constitutional lawyer, so I'm certainly not sure what all the variations might be, but certainly there's a range of options from keeping the law intact to declaring the entire act null and void because it's not severable. And in other words, you can't separate the individual mandate provision from the rest of the bill. And there's some good reasons economically why severability has good and bad to it. For example, the main concern being that if the mandate is removed, then the requirement to provide coverage for any type of condition and to allow quite liberal movement in and out of policies will send premiums skyrocketing, and that's certainly not a desire of anyone in either party.
If the Supreme Court were to find the ACA unconstitutional and non-severable, what's going to happen to the law's provisions that are already in effect? Such as coverage to the age of 26, the MLR reporting and rebates, health plan premium increase review, so on.
Well, if it was to be found null and void, essentially, because not severable and the mandate was struck down, all of those provisions would go away. That, not to say they couldn't be brought back, and typically one might expect a rapid response, perhaps even led by the Republicans, who might be concerned about the political ramifications of winning the battle that they set out to win, because there would be some concern that the provisions of the ACA that are very popular being struck down would probably create some backlash in the population. So you would see a new bill introduced, and it might have bipartisan support. It's hard to predict what that would look like, how quickly it would move through Congress, but certainly there could be the introduction of new legislation. But it would require new legislation if the entire act was struck down.
What do you think will happen to the quality efforts that are currently underway, such as the Pioneer ACOs and shared savings ACOs?
Well, there are many types of quality initiatives underway. Some of them are just a part of CMS's ongoing activities. Some of them are being driven in the private sector, like private exchanges and pay-for-performance in the commercial sector. Those would be unaffected. But the initiatives that are directly funded in the ACA would be struck down. So Pioneer and shared savings ACOs would lose their funding, since CMMI, the Center for Medicare and Medicaid Innovation, was funded in the bill. So presumably that funding would be struck down, the programs would lose support. It's possible that those programs might be sustained by CMS out of its regular operating budget. That is possible. That would be mere speculation.
Do you think there'll be any effect on the health care information technology efforts that are currently underway?
Well, healthcare information investment is a very broad topic. The specific monies associated with the EMR adoption were in another bill. They're in the HITECH Act, and that should not be affected by anything that happens at the Supreme Court. So I think EMR adoption, that process will probably continue. There might be some change in the pace of it, but overall it wouldn't be dramatically affected, I don't believe. The investment in HIT is much broader than the HITECH Act, however, and a lot of that investment is being driven by the belief in the industry, all parts of the industry, payers, providers, ranging from primary care doctors to specialists in hospitals, the sense that the changes that are coming from the Affordable Care Act are going to drive much greater degree of accountability for integrated cost and quality management in the delivery system. And that concern and desire to support those trends is what's driving the broader investment in HCIT. So certainly the bill being struck down would be a very damaging blow to the adoption of HIT and the pace of that adoption across the country.
There's been recent rhetoric from GOP presidential candidates stating that they will all repeal the ACA if elected. If the Supreme Court were to uphold the ACA, would a GOP president be able to repeal it?
Well, again, I'm not a constitutional lawyer, but it would strike me that any bill can be repealed by Congress. So the notion that the president's going to repeal a bill, obviously that's not the case. I think what the candidates mean is that their party, presuming that their party were to seize control of both houses of Congress in the victory, would then introduce legislation to repeal the ACA. I believe that's what the claim really boils down to. A president cannot repeal this legislation on his own accord.
Why do you think that a majority of Americans believe the Supreme Court should rule the ACA unconstitutional, even though when asked about specific provisions, such as coverage to the age of 26 for dependents, they support primarily everything except for the individual mandate?
Well, this is just personal opinion. I think that there is a broad concern in the American population about more government control and intrusion and requirements. I think that's true. But I think that the reason why this is particularly bothersome for that small majority of the population is there is a concern that the mandate will bring much higher costs than are anticipated today. That the mandate will in fact drive up premiums for everyone and create a new entitlement or an expanded entitlement in health care. And there are many arguments about that position. One might argue, for example, that expanded coverage will actually contribute to lower costs in the long run. But that's a very difficult argument and one that has been very politicized. If you remember, during the run-up to the ACA's passage, there were various statistical groups that were issuing forecasts on the impact of the ACA, and these impacts could not have been more different in the predictions of the far right and the far left. No one really knows, obviously, what the net effect would be, but I think many Americans are concerned, one, about the idea of a new government requirement, and two, about the costs that may not be well understood that would come from expanding coverage to these tens of millions of people who are not really covered today.